In a medical malpractice case where you have sued your doctor claiming that he was careless, causing you significant harm and injury, during the course of your lawsuit, when you are asked questions in a pretrial question and answer session known as a deposition, can the defense attorney ask you questions about what records you have reviewed in preparation for your questioning? You want to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, he can. The defense lawyer has every right to ask you what records you reviewed in preparation so that you could prepare yourself for these questions that you are now being asked by the attorney who represents the various doctors whom you have sued. The defense attorney wants to know if anything that you reviewed refreshed your memory. If it did refresh your memory, now the defense attorney will ask you questions about whether you reviewed your own medical records. It's either yes or no. The defense attorney will want to know whether you reviewed any notes that you may have made during the time that the doctor was caring for you. That's either yes or no. The defense attorney will want to know whether you have any diaries or notes or calendars describing anything that the doctor did, including any conversations that you memorialized or recorded so that you could remember later on about the events that transpired. Here's something else you may not know. If you answer yes to any of those questions, that you did in fact review certain records before you are answering this attorney's questions during this deposition, which by the way is also known as an examination before trial, the defense lawyer has every right to ask to see those records. That's true. He will want to know, did you see those records? Did you review them? Did you get copies of them shortly after this lawsuit was started, or was it before the lawsuit was started? If it was before, he will want to see those records. Do you have any notes or diaries or calendars about conversations that you had? If the answer is yes, he is legally entitled to ask for it, and we now have to provide him with copies of whatever it was that you had made. Now, why is that? It's because the defense lawyer is entitled to ask you questions about anything that helped you refresh your memory about the questions that you knew you were going to be asked during your deposition. Before you are questioned, your attorney will meet with you before, it might be the day before, it might be a week before, at some point before you are scheduled to answer this lawyer's questions. Your attorney will prepare you. Now, when I say prepare you, it doesn't mean that the attorney is going to tell you what to say. Some people think that. Some people think that when an attorney prepares their client for a deposition, that basically they tell them, okay, here's what you have to say. No, 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 that's not what happens. What happens is that the attorney will go ahead and ask the client, you, the injured patient, of the types of questions that you are expected to be asked. Now, how does the attorney know this? Now, how does your lawyer know what questions are going to be asked? Well, if the attorney has been doing it for any length of time, he will know exactly what questions are going to be asked. They will ask you about conversations that you had. They will ask you about what it is that you remember. They will ask you what prompted you to go to the doctor and what complaints you made on each and every visit. They will also ask you what the doctor did. In other words, they want to know what your observations were and what you remember. Another thing you should know is that this is not a memory test. So if you don't remember specifically something happening, it's okay if you say, look, I don't remember. It's been many years since this happened, and I don't have any notes about what occurred. That's okay. You know why it's okay? It's because the doctor is required to create notes for every office visit that occurs. And now I will have an opportunity later on during the course of this lawsuit to go ahead and ask the doctor questions about what he did and why. So now let's get back to you. If you reviewed various records in preparation, and by the way, these records could be photographs. If you reviewed photographs, yes, the attorney will be allowed to see those photos. If you reviewed notes, texts, emails, the attorney will be allowed to go ahead and review those. Now you might be thinking, okay, what happens if you don't have access to them at the time that you are being questioned? I'll tell you what will happen. The attorney will likely go ahead and ask you for copies of them or to preserve copies and give them to your attorney after this deposition is finished. And now he's not technically going to finish your deposition at the end of the day. He's going to hold it open. He's going to say, look, I reserve my right to bring you back to ask you additional questions after I've had an opportunity to go ahead and review those records that you actually reviewed in preparation for today's deposition. And it is possible that after you have located those records, provided them to your attorney now gets them over to the defense lawyer looks at those records. He may say, you know what, I really need to get you back in to question you further about the records that you have provided. I need to understand what notations you made. I need to understand what this means. And so now your attorney will have no choice but to go ahead and schedule another deposition for you so that the defense lawyer can ask you additional questions about whatever it is that you reviewed in preparation for your questioning during your deposition. So why do I share this great information with you? I share it with you just to give you an inside look at what really happens during the course of a medical malpractice lawsuit in New York. You know, I realize you're likely watching this because you probably have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.